Good morning, Owner Summit. I'm Gabe Levine. For those of you who don't know me, I have a law firm called Groundwork Legal in the San Francisco Bay Area. I work mostly alone. I have one person who works for me, and I don't get to collaborate much. So my good friend Josh here reached out in 2011, shortly after the infamous "fuck you, pay me," and said, "You get a laugh if you just say the title," and said, "Hey, thanks for that." And a number of people had thanked me, that own agencies, and I was like, "Yeah, this is great. Thank you all for giving me money and liking me." But I hadn't heard from a lawyer, and lawyers are a delicate bunch. So hearing from Josh was really nice, and he was the first person to reach out. There were more, and other people I talked to, but Josh knows what he's doing, and that's frankly rare amongst small firm lawyers. So and it was way more than a month and a half ago. We've been doing this like 9 months. I flew to Portland, he came down to San Francisco. It's just Carl's world is like accelerating. I said, yes, I will do this. I would love to do this. I've wanted to do this for a long time, but I am not doing it alone. I want the one other guy who serves digital agencies and does it well to do it with me. So I pinged Mr. Barrett, did a little bit of convincing, and got him along. So I'm going to let him tell you a little bit more about what we're doing today.
Yeah, hey, nice to meet all of you. I recognize some of you as clients. It's nice to see. So I'm from Portland. My firm is Create Legal. I've been in this racket for about 20 years, about 15 years before I went out on my own and started focusing on helping exclusively digital agencies. My practice, like Gabe's, is business, employment, some tax, mergers and acquisitions, owners agreements, all those different types of things. I'd say the one thing that Gabe and I have mostly in common is contracts. We look at, review, negotiate, fight about, argue about, laugh at lots and lots of contracts. And so that's why it sort of made sense for us to get together and think about how we could take some of that experience and put it to good use for the Bureau and maybe standardize some of these things. And while we rail at lots of contracts that we see and their problems that they have, we thought that we could get together and build something that's a solid foundation for all of you to use. So today we're happy to announce, as Carl mentioned, the Bureau standard form of agreement for digital agencies, or as Gabe and I call it, the Bureau Agreement. And it is available for download right now from the Bureau's website. If you go to Bureau of Digital Standard Agreement, you can pick it up right now. Now that download consists of 3 parts, actually. The first part is obviously the agreement. We've also included the second part, which is a standard statement of work. In that statement of work, we've included some sample language and some recommendations on how we think SOWs should be structured. And then lastly, we've included a user's guide, which is an explanation, negotiating tips, disclaimers, all sorts of the information that you need to put the standard agreement to use. The 1.0 version of the standard agreement is made for agencies that do design and front-end development. And we hope to expand on that as time goes on, and we'll talk about that a little bit later. But before we dive into that, Gabe's going to talk a little bit about why this thing came to be.
All right, and downloading will help you guys follow along a little bit with our presentation. So while you're doing that and giving Carl more information about yourself, I'm going to talk about why. So Carl stole a little bit of my thunder in the, how this thing came to be.
I'll steal more if you're not careful.
Constantly stealing so much thunder, Carl. Why? So there's a few reasons. I had some booked out, right? We want to give you guys a guidepost to use. Not something that you just pull off the shelf and you go present to your clients, but something you can use with your lawyers who don't maybe know your industry very well. Something that's a collective knowledge that we've gained through our practices from you guys and from our interactions with opposing counsel. So it's a guidepost for you. That's obviously simple point 1. But the far more important goal here is to really make this thing a standard. So for any of you who negotiate contracts, how many times have you heard, but it's industry standard? And we hear it all the time, right? And the thing is, whose industry are we talking about? If you hire a general contractor, do you tell him that your contract is industry standard? If you hire a lawyer, do you tell him or her that the contract that he or she needs to sign is your industry standard contract? What about a doctor? It's the service provider that dictates what the industry standard is for the contracts. That's pretty much always been the way it's been. Yet we have large tech companies, we have small startups that are, got their pull down from the large law firms in Silicon Valley telling us what the standard agreement is, and it's frankly fucking annoying. So in negotiations, I know both Josh and I use this in as delicate a manner as possible, but we say, I represent hundreds of these agencies. I think if it was standard, we would know about it. So we want to make this thing really standard. It needs an adoption rate. It needs to be put out there in the world. You guys have to use it. You have to talk about it. It has to become something real. In conjunction with that, you put the Bureau's tag on it, and that does something that's good, I think, for both the Bureau and for us, and for the agreement itself. We want to boost up the Bureau. We want to boost the agreement, and we want to make this thing something more than just a tool for you guys. We want to make it a negotiating tool for us. Josh?
So one of the other things we wanted to do in this that's probably different than a lot of agreements you've seen is we wanted to write it clearly. And where did that get a laugh? I'm very serious. We labored quite a bit on making this as clean and efficient as we could. Did a lot of work to avoid legalese. Writing clearly is not just getting rid of legalese. There's also a big business point that goes along there. When you write clearly and communicate well, just like in your design work, it increases trust. It increases the speed at which you move through your negotiations. It gets you from proposal to deposit more quickly. These are all real, tangible business benefits. I was thinking this morning, there was one point where Gabe and I were going back and forth, and I found some edits, and I said, well, if we do it this way, it'll make the agreement, 4% fewer words. And so those were the types of efficiency things we were doing to keep it a nice, tight piece of legal writing, and we want to continue to improve on that as well. We also wanted to draft it fairly, and we've seen some other standard agreements that are very one-sided in favor of the agency, and quite frankly, a standard is not a one-sided agreement. A standard is a mutually accepted standard, and that's what we tried to accomplish with this document. We pitched it fairly down the middle. It does lean in favor of the agency's first negotiating position, but these are the professional standards as businesses that you'll have to stand up to when you deliver your services. Doing a standard agreement that is fairly written and down the middle also has business benefits in that it takes less time to negotiate. If you start completely on one side, it's harder to get toward the middle. So we wanted to get you, again, from proposal to deposit more quickly and get on to the paying work.
All right, now it's time we introduce. We only had a headshot of Carl, so we just used it twice.
Oh, now I am going to be an asshole client. I can feel it coming.
All right, so yes, Carl, in his natural role, is going to be playing the sort of know-it-all client that you've encountered on the phone before, who gives you those lines like, "Hey, it's not industry standard." And Megan is going to be the sage and patient agency representative. And the first issue, because you know what, you got to be with these procurement assholes. The first issue we're going to tackle is an important process one, and it's around acceptance and rejection of work. So please take it away.
First, I just want to say, I don't know why they canceled your hotel room. I have no idea. Look, Megan, I've read over this provision about accepting work, and you're asking me to reject what you send in 5 days. I can't reject it in 5 days. I've got to reject it. I've got to send it to my boss to reject it. We need 30 days to reject whatever it is you throw at us.
All right, let's take a little pause there and talk about what Megan has to deal with here. So a couple of approaches in dealing with this. First, I think it's a real opportunity for the agency to educate the client about what 30 days of approval really means to a digital project. I mean, it's an eternity, especially if you have a number of iterations. We want the agency, obviously, to get that as short as you can. One possible compromise is to suggest that the client get a staff member that's authorized to act and give approvals on the project. And if you have to, agree to a reasonable amount of time for deliverables to be approved, subject to a backstop 5, 10, 15 days. So let's check in on Megan and see how she deals with Carl's request.
Carl, you're focusing a lot on rejecting the work, but it's also accepting the work, so keep that in mind as well.
All right.
I know that seems short, but that's what is going to keep the project moving. So if you really have to take 30 days and you use all of those days, the project is going to go on much longer than you want it to, and that's going to increase your cost because it's using more of our time. So I can give you more time, but it's going to increase the schedule and the cost of your project.
All right, well, then how can we manage these timelines?
If you can establish somebody on your side who's a single point of contact, who has the authority to make those approvals quickly, we could adjust the language to say that you have a reasonable amount of time to make approvals. But no matter what, we need to have some kind of a backstop. We could do 10 or 15 days, whatever it is, just understand that the longer it takes, the more our schedule and the budget is going to get pushed out accordingly. But if you set a single point of contact who can give us those approvals, that'll help keep things moving quickly.
Okay, I can meet you at 15 days. I've got a staff member that I can put on it, but you got to keep them in the loop. I mean, that's on you.
Absolutely.
All right, I don't think Carl's quite done on this clause. I think he has some feedback on the standard, what types of work can be rejected or accepted in the materiality standard.
Also in this paragraph, I have a problem with the statement that says we can only reject the work for materially failing to meet specs. I think we need to be able to send it back if any part doesn't meet the spec. And besides, what does material mean anyway?
So let's give Megan some ideas on how she can deal with this pretty common request. So I think there's a trade-off here, and it really comes down to whether or not the client has done a good job of interacting with the agency to provide the detailed specifications that are necessary for the agency to build to. If the client has not engaged in that type of process, I think a very fair answer is no. You have not provided us the specifications necessary to build to. We're willing to iterate with you throughout the process, but we need some flexibility, and that's why the materiality standard is in there. But maybe it's also an opportunity to sell a scoping phase of work where you can iterate, where you can do some research with the client, get some information that's necessary to build a technical or functional specification, whatever is necessary in order so you have the detailed standards that you can build to. So let's listen in on how Megan deals with Carl.
So how's Megan going to deal with Carl?
I don't know.
Yeah.
So that language is in there because our current understanding of the specifications right now are pretty generic. So we can accept this change to the language, but only if you can help us really clearly define the project specs in the SOW prior to signing.
That's fine. I mean, I thought the general statements we gave you were okay, and we just figured out as we went along. But
I wish we could do that, but we really need to have objective standards that we're working against. So another option we could look at is a short, separate, paid scoping phase where we help you define the specs that we need to work against. Would that help you out?
Well, I think our internal team already did some of that work. We've got the functional specs. I just didn't realize how those would work in an SOW. So I'll have someone on my team reach out and get you that information.
That's perfect. So get us that info and I'll put that into the SOW and we can move forward.
Didn't that work out nice? The thing about negotiation is some things are going to work out, some things aren't. You're going to have 2 or 3 rounds, right? So we're trying to make this somewhat realistic. And some clients think, can we just get on a call and work this out? Sometimes there's a lot of pressure from your client to have the thing done yesterday, which is really kind of a shitty tactic that you're up against. It rarely happens. If you've got serious issues to talk about, there's going to be a few exchanges of emails, there's going to be a few rounds of negotiation. Some things get worked out, some don't, at least not immediately. All right, so they worked that one out. Let's talk about a slightly tougher issue, which is the transfer of rights on payment. In other words, we'll assign you the copyright, trademark, et cetera rights to the deliverables that we create for you only when you pay us.
So this is work for hire. We need to own our website. So we got to get rid of the subject to payment language. If we don't pay, you can sue us for breach of contract.
All right, let's talk about this a little bit. What's the leverage, or what's the reason we do this? It's for leverage. The reason that lawyers include this clause is if your client doesn't pay you $25,000 at the end of the project, you want to be able to say you can't use that website, right? Putting aside the issue of the kill switch, which is not something I recommend people use for a number of reasons, i.e. flipping off the website if they don't pay you. Don't do that. It's dangerous. But having the legal right to say you can't use the work we've created for you is real leverage. It's just not that good. If you don't register the copyright within 90 days, you don't really have any legal rights that are going to make the other side quiver. You have to prove damages, and you're not really going to be able to do that. But you need leverage. You need leverage to get paid. So what's there? What's there for us? The attorney's fees clause. And this isn't intuitive to a lot of people. A lot of people have heard me talk about it before, but this is the single most important piece of leverage you have to get paid. Why? So you're owed $25,000. It's a lot of money, but it's not a ton. Even $50,000. Litigation is massively expensive. Even to get the complaint prepared, we're talking $5,000, maybe $10,000. So the other side is doing this calculation, and if they have attorneys or they're sophisticated and they know how this works, and every big company does, they're saying they're not going to sue us for $25,000. There's no attorney's fees provision in here. They have a decent case, but they're just not going to do it. And what's our risk? Our risk is $25,000. We've got in-house legal. We can deal with the early stages of litigation, send over some standard discovery, make them work. They will have paid their attorney $50,000 and $20,000 before we get out of month 2. You're fucked, right? The attorney's fees clause fundamentally changes that calculation. The prevailing party has to pay the other party's attorney's fees. Their calculus just went, okay, we could lose $125,000. Let's try to settle this. Let's offer him 10. Let's offer him 15. It gets resolved. And in real world practice, I've had dozens, if not hundreds of these types of disputes. It works. So if you're going to kind of play the negotiation the way you should, my recommendation here, and the way we've sort of drafted this is you say, okay, sure, we'll give you that. Let's see what Megan does with it.
Let's see what I do.
Yeah.
I totally get it, Carl, and I want you to be able to do whatever you want to do with your site. I'm not trying to own your site. This is really about leverage in a payment dispute. So my attorney says that I can agree to this change, and we could even add some work for hire language if that makes you more comfortable, as long as we have a prevailing party attorney's fees clause so that there's an incentive to resolve a dispute over payment.
Yeah, I'm fine with that. I mean, if we're going to put in an attorney's clause, I just can't have my website held hostage. I have to own my website.
Yep, I totally get it. Let's make that change.
Great. Looks like they got that one resolved. I think Carl has some feedback on the portfolio rights clause. Let's see what he has to say.
I need to make a change here. I can't have you using our logos and work in your portfolio without getting our consent first. I mean, we have to manage our brand.
Okay. It seems like this has become a more and more common issue in the agreements that I've been negotiating. There's a number of big sportswear apparel brands in the Pacific Northwest that are very adamant about these things, and I have a lot of clients that deal with them. But the fact of the matter is the portfolio presentation is an important part of value that you receive in exchange in addition to a few dollars. So a couple ways to deal with this. One, if you think portfolio rights might be a challenge, or if you start to get some feedback about portfolio rights, one idea is to pitch your work at a price that's high enough to compensate you if you don't get portfolio rights. And when the client says, gosh, that's a little higher than I expected, you have a little negotiating room to say, well, if we can be sure to get portfolio rights, we can adjust that price downward a bit. Another approach is to try and make the portfolio rights that any approval won't be unreasonably withheld. This is fairly common language that us lawyers come up with. Won't be unreasonably delayed, it won't be unreasonably withheld, and sometimes that can solve the problem. Another approach is to address the fact that the client likely found your agency in part due to your portfolio, due to what's on your website, and they like what they see. And you're very proud of your work, and I think you can appeal to that and say, look, we want to include your work alongside these, our other typical portfolio presentation. We're not going to do something crazy with it that you don't expect. You can see exactly the types of things that we're doing. And I tell you what, if you can consent to this typical presentation, if we want to do something else, like write a white paper or submit it to a design competition, that we'll come back and we'll ask for your consent on that. So maybe because they've seen your portfolio and they like it, they're predisposed to agreeing to that type of change. So let's see how Megan deals with Carl's request.
Okay, I get where you're coming from, but the pricing that we gave you is based on us having typical portfolio rights. So if we don't have those portfolio rights, then we might have to look at pricing differently.
We're not going to increase the budget, so we can't do that.
Okay, how about this? I could add language that says typical portfolio use is fine. You've seen our portfolio on our website, so we would use it in the same way that we typically display portfolio work. That's how we would share your work as well. And we can add a clause that says if we're going to do something different than what we typically do and what you've already seen, then we'll ask you.
Okay. I'm going to be hell to work with, by the way. I'm going to do this now.
It's never that easy. Portfolio rights is a tough one. But this is a doozy. I'm going to try not to lose you guys here. Infringement liability. So I'm actually curious. Has anybody in this room ever received a letter from a client or anyone else about some sort of infringement arising from your work? Copyright, patent, trademark? One, two,
Handful.
3, 4. All right. So we got about 100 people probably in this room. 4 out of 100. That's enough for me to feel good about all the time I spend on it. I mean, it's funny because clients ask, is this really something that is going to come up? And the answer is no. Most of the time it's not. But if it does, it can be a company killer, right? I mean, I had a client that was going to do some work with Samsung. They were going to help Samsung design a TV. It was going to have some functionality to be able to control the TV like that with your hands and gestures. You think there's a possible patent lawsuit there? Yeah, that could happen. So we negotiated, and we negotiated for a long time, and I told the client at the outset, this is the issue, right? This is the thing that, it wasn't a ton of money. It was enough money to really make them want the project, but it certainly wasn't enough money to ignore this ever-present issue. Now, if you're just designing a website, the risk is even lower, right? But it's still there. And so we spend a lot of time negotiating to protect you guys in this. Some things to think about. Trademarks. Are you doing clearance for the trademark? Probably not. Is it part of your budget to do so? If you're doing any branding work, you need to think about that. Copyright. Make sure your people know not to just pick up stock photos, drop it in, and never say anything about the licensing terms, right? Your client, if your agreement isn't careful about that, your client's going to assume they can use that stock photo anyway, which way forever. So your agreement needs to be specific about that. Font licensing, things like this, they're important. So if you make a promise, look, nothing that we give you is going to infringe anybody's intellectual property, you're setting yourself up for a potential suit. What do? We try to put on something called a knowledge qualifier. We say, look, to our knowledge, the deliverables we're giving you are not going to infringe any third-party IP. That's helpful. It's not foolproof because one of your employees could do something they know is bad, and then you better have good insurance, which is another general note. But it's a big amount of protection. What else do? We try to keep the indemnity obligations, your obligations to protect your client, in the case that somebody sues them or brings a claim against them, limited to your breach of that knowledge qualified warranty. You'll sometimes see an indemnity obligation that says, if some third party comes along and claims that we've infringed IP by virtue of our website or this piece of software that you've given us, that's on you. Well, that just makes you their insurer, right? You're just liable no matter what you knew, no matter what you did. It's on you. So we try to tie that indemnity obligation to a breach of that warranty. And lastly, we give you some protection in the form of a limitation of liability. And you will frequently hear people in negotiations and see people in negotiations on the buyer side trying to carve out indemnity from the limitation of liability. And that's dangerous waters. So we're going to talk about that a little bit here too. So I want to set the stage for what is going to be kind of a technical conversation between them, but I think it's worth having. So let's hear it.
On the IP reps and indemnity, we need you to stand behind your work. We need to make sure that we don't buy an infringement lawsuit. It can't just be what you know about, and your liability for indemnity cannot be capped. We have never worked with an agency that is not willing to stand behind its work.
I appreciate your concern. On our side, I hope you can appreciate that I can't take on liability for things that are outside of our control, and like trademark and patent infringement. So we haven't budgeted to pay lawyers to do IP clearances, which is expensive and kind of non-committal anyway. So we don't actually know for certain if the ideas or designs we give you could infringe some crazy patent or trademark that's out there that we don't know about. So I can indemnify you if we knowingly steal someone else's work to use for your brand, and in general can stand behind our work. And that's why we include warranties around performance and quality and service. But we have to focus on what we knowingly infringe on, because we haven't budgeted to seek out all of the patents and trademarks that could exist.
Well, I mean, you have to understand this is pretty concerning. We haven't had an agency that's not willing to stand behind its work like this before. You are the professionals in web design. You should know what is out there that could infringe. We're never going to know.
All right, so this is a really common tactic to discredit the agency, right? Stand behind your work. You should know. Really? Are you guys expert? Raise your hand if you're an expert in IP clearance. Jen. Anyone go to law school? Oh, God bless you.
Josh, you didn't go to law school?
Are you an expert in IP clearance? I'm not an expert in IP clearance. So you're not a pro with this, and you need to tell them that, right? If this sort of negotiation comes up, this tactic is common. You say something kind of like,
So I'm surprised that you've never had any other agencies push back on this. We always push back on this. And the standard agreement that we use for digital agencies includes a knowledge qualifier on the IP infringement, doesn't have a carve-out for indemnity on limitation of liability. And we go to industry events all the time. Our colleagues are doing very much the same thing. So certainly, we're professionals when it comes to website design, but not when it comes to IP clearance. We're not a huge agency. We don't have in-house lawyers. And like I said, we don't have a budget to be doing clearances for you.
So you feel it's reasonable for us to take the risk on your work? Someone could sue us for $1 million for you infringing on a trademark that we have no clue about.
Another good argument, right? You're giving me a thing, and that thing ends up costing us $1 million. Why should we pay for it?
Yeah.
It's a tough one, and there's a number of responses. Having this conversation with your clients on the call, some of you in the room have been on calls with me where we have this conversation, can be utterly awful for the business people. These two are pretty sophisticated, but some business people are like, what the are you talking about? So I thought about this one time, and I was like, what, really, what is the justification? And it's actually a pretty reasonable and straightforward justification. So let's hear Megan explain it.
So this is a fair question, and I want to just be really transparent with you. So you're paying us $50,000 for the site. So it's not chump change, but it's not like a windfall for us, right? You're hiring us because you know we're good at what we do, you like our work. You're hoping that the $50,000 you pay us to do this work for you generates more than that for your company in terms of new business or value. So your upside potentially is way more than the $50,000 that you're paying us for this product, this work product. But my upside as an agency, let's say I make a 30% margin on the work that we do for you, that's $15,000. So my total upside is 15 grand, and I can't afford, as a small agency, to take $1 million risk on potentially a $15,000 profit. Now, what I can do is offer to have the indemnity claims increased to the extent of available insurance proceeds.
This is a neat trick. And one that works sometimes, even with big companies, right? So why is it that these big companies are asking relatively small and sometimes very small agencies to pony up for potentially millions of dollars of liability, right? Oh, it's $1 million standard liability cap. Like, would that fucking kill your business or at least your year? I mean, it would kill mine. $1 million, boom, like that. So what's the point? Well, they think that you have insurance that covers this. Sometimes they require that you have insurance that covers this. You should have insurance that covers this. You should have a good insurance broker. You should have an insurance broker who understands your business and one that can answer your questions and talk to you about your policies. That's point one. Point two, they also want to spread the pain, right? They have a lot of people work on a lot of different things, and so they have a lot of different pockets to pick. They're not actually expecting that everybody's going to come up with $1 million. But back to the point at hand. So the concept with this proposal is you are on the hook only up to the extent of the monetary cap. Let's say you get really lucky and it's the amount of the particular SOW that you're working on. So it's $50,000, like Megan said, that's what they're getting for this site. That's your liability cap. But Carl says, look, I put this thing out in the world, I get sued for $1 million, I need something more than $50,000. And you can kind of concede to a certain extent that that's reasonable, but I can't take that all that risk. But if we have available insurance proceeds, if we have dollars from our insurance to pay you, well then yeah, we'll pay you. And again, something to talk to your broker about, get those policies in place, but this is good cover. And this, frankly, when I have a client that understands its insurance and a good broker, I'm like, thank you. It makes the negotiations easier when we're talking about these heavy liability projects. And so as we finish up this discussion, just notice, I want to reiterate, they don't necessarily resolve all the issues here. They're not supposed to. That's not the way it goes. So we're trying to make that a little bit realistic.
All right, so I can understand $15,000 and $1 million. I see where you're coming from there, but I can't just approve that. I have to get approval. It could take just a little while, but send over your E&O and your CGL policies and not just the declaration pages. Also, I won't be able to get this through if the dollar cap is just one project. It's going to have to be at least the amount we pay under the whole contract if there are multiple projects.
If we can have the knowledge qualifier, at least on the patents and the trademarks, and keep the limitation of liability on indemnity claims, then I think I can agree to that.
All right, I don't know. I'm going to have to go back and get approval. So I'll just get back to you on that.
Okay.
Great. I want to add one more thing before we jump to the next issue on this intellectual property matter. I have started to see a lot more contracts requiring the agency to actually do trademark pre-clearances on any names, logos, or taglines that they submit. And global ad agencies have internal business affairs people that can do these types of things, but I suspect most, if not all, of the agencies in this room do not have that type of resource or expertise at their disposal. And I've seen these clauses creep out into, contracts not just for global brands, but for other brands as well. It's a huge source of risk shifting, and it's something that you need to be aware of if you do anything with names, logos, and slogans. So keep an eye out on that. So wrapping that piece up, we're going to jump to one little ping pong issue at the bottom of the agreement, the governing law clause. Let's see what Carl has to say on this one.
Okay, about this governing law clause, I have switched this to our state. You're doing work for us. We're going to be the ones that own it. It gets resolved in our state.
So I'm sure probably everybody has gone through this negotiation, this ping pong back and forth. Where is it going to be? So 3 pretty practical ideas here. Remember, this clause actually is not going to be triggered, is not going to come into effect unless you have a dispute, and then that dispute actually turns into something where people are filing complaints in state or federal court. Most disputes get resolved short of that, even fairly heated disputes. So I think you can be pretty practical in how you resolve this type of clause. One option you can always use is just to delete it. Just take it out of there. Trust me, the lawyers have ways of figuring out governing law and venue if, in the unlikely event, you end up in one of those litigations where you do have to go to court. Second, as for governing law, for these types of contracts, it's not going to make a ton of difference. Forum does make a little bit of difference, but again, I think this is beyond our 1 in 100 type of situation. So deleting it is a fair approach here. Another idea is to concede to the client's wishes, but use it as a bargaining chip for something else. This is I see clients really latch on to this. This is very important. They have policies, they can't change it. But if you can give it up and get a knowledge qualifier or get an attorney's fees clause or some of the other things we've talked about, you've come out way ahead in terms of protecting your business. Another option that you'll sometimes see is agreeing to forms of mutual inconvenience. So if the client has to sue, they have to come to the agency state, and if the agency has to sue, they have to go to the client state. And hopefully that disincentive encourages people to resolve it because nobody wants to go through that type of process. So let's listen in and see how they deal with these types of things.
I think it's so unlikely that we're going to have a dispute. So instead of going back and forth about it, why don't we just delete this clause? I don't think we'll have a dispute where it matters. And if we do, the lawyers can just sort it out when the time comes. It's not really worth arguing about.
You can just delete a clause?
Yeah, just like Control V.
Who are you? There's no way I'm ever going to get it approved that we just removed the clause.
Okay, why don't we do this? If you file suit, you come to my state. If we file suit, we'll come to your state. So it's a clause of mutual inconvenience, and that's going to encourage both of us to have proper dispute resolution.
That's creative. Let's do it.
Business.
Well, I think they got it just about wrapped up, at least for this discussion. Let's say thanks to our guinea pigs for helping us out. I think it's important. One thing I want to just say, why did we introduce the standard form of agreement and immediately dive into negotiating it and haggling it? And the one thing I always tell my clients is that contracts are not a substitute for communication. Like, even if you have a standard agreement, even if it's blessed by the Bureau and there's hundreds of people using it, you're still going to have to get on the phone with other people and have a conversation just like we saw today. And you're going to have to work these things out. People have different levels of experience. Everybody brings that to the table, and you need to listen to your clients, and you need to think about what they're dealing with and what they're going through and how you can help address that. And so just beating them on the head with the standard agreement won't work. You're still going to have to do this type of thing. So that's why it's important and why we wanted to share some of those communication strategies that you're going to have to use in dealing with these. So let's talk about what's next. First of all, hit that download page, grab the package of stuff, look it over, and let us know what you think. We're both on the Bureau Slack. You can hit us up on Twitter, drop us an email, catch us after the show. We'd be happy to talk to you about those things. And also take it and talk it over with your partners and with your lawyer in your own state, the people that your other advisors, and get feedback and get it customized for your business. Again, even though it's a standard agreement, there are things about your workflows, your deliverables, your branding that you want to reflect in this agreement, and you'll still need to do that work. But this will put you on a solid footing to getting those things moving forward.
All right, so what's next for us? We're going to take that feedback, which you guys are going to give us, please. I don't want to hear from lawyers. but that'd be okay too. I want to hear from you guys. We have a number of different statements of work that we're already planning to create and roll out that'll be more focused on other types of work that agencies do. As Josh said, this particular version 1 statement of work is for a relatively straightforward website design with some front-end coding, like a WordPress project. But we're going to do a branding-specific statement of work, most likely, that tackles perhaps some of those trademark issues we were talking about a little more specifically. We're probably going to do one that is focused on marketing and search engines. I know a lot of you are looking at and engaging in, at this point, retainer-type models. So we're probably going to do a statement of work that is focused on that sort of model. And we may even do a sort of heavy lift development type one. So those are in the pipeline, things that we'll probably do over the next couple of years. And then we plan to iterate and versionize the agreement as we sort of get more information from our own practices and more information from you guys, and maybe roll something out quarterly or twice a year on that. But to do all this and to make it work, I really, really want to say this has to be something that's pushed out. It has to be something that's amplified. It has to be something that's adopted. And the goal here is not just for Josh and I to stand on this stage and give you something that you can kind of be like, okay, cute, click, or download it, or to be a standard agreement. This is to try to give you a little more leverage, to give us a little more leverage, to give your lawyers a little more leverage, to negotiate and level the playing field a little bit, because the standard agreements that come from these big companies are fucking ridiculous. They just are. There's no, I hate the conversation I have to have a dozen times a month where the client is like mildly optimistic that this wonderful project they've landed is going to come with not a horrible agreement. And like 1 out of 12 times, I'm pleasantly surprised that the agreement isn't horrible. But the other 11, it's fucking terrible. So let's do it. Let's make this thing what it's intended to be. Thanks again, guys. Thank you, Josh. Thank you, everybody.
That's good. Thank you.
We do have time for some Q&A.
Yeah, Q&A.
We've got the catch box over there. Mark, grab it.
Somebody wasn't paying attention.
Hi, Gabe.
Hey.
So your answer to my question might be that
Let's talk later.
out of scope,
It depends.
a legal discussion. But I'm curious about the clearing trademarks and IP, and a lot of our work is with organizations that also have many internal teams who are producing work. I'm curious if the conversation ever comes up like, well, what do you do to clear all this work internally? Can we be a part of that process? Because as you guys talked about, you're hiring us to produce this website. We're not trademark clearance experts. And so
when you say, can we be a part of that process, are you talking about participating with the internal team or?
Well, you mentioned if it's a big organization, they may have a person or team whose responsibility it is to make sure the work that's produced is not infringing on any trademarks.
Right.
Yeah.
Why can't they handle that?
Right.
Because we're not experts in that. Or I wonder if the answer might be, well, we're actually not doing anything to clear those trademarks, and we see an opportunity here to put the risk on you instead of owning that risk ourselves.
Yeah, and if the clients are doing that, putting the risk on the agency because they're not doing it, I mean, they're foolish in 9 or 10 different ways, but let's be a little bit more optimistic. So if you are doing a branding project, what I recommend, and you think it needs to go through a formal clearance process, is build that time frame for clearance. When you present concepts and they select one for development and into final, they need 6 weeks to go talk to their lawyers and do clearances. And I know 6 weeks in the middle of a project is terrible, but if you put that on the schedule and push it out there, they're going to say, well, what's this about? And now you have an opportunity to have that conversation about responsibility. I think the important thing to remember is that trademark infringement is based on use. It's not just based on creating something that is similar, it's based on use. And the agency is not going to use the mark in commerce. Only the client is, only the brand is. So they're really the only people that can make the judgment as to whether or not something has risks associated with it or not. So I think you have a lot of points to enforce on them that they need to have that, they need to take on that risk. And they're the best people to do it. They know how their brand is used, the products, the markets, the services, the countries. It's just really difficult for most smaller agencies to take on.
And I'll add, Mark, a client who I know is not in this room, but we've done this a couple times. They're really focused on branding, and he's willing to, these projects are mid six figures, so they're good sized projects, but he's willing to go back to the drawing board and without increasing the fee if they come up with a solid enough ping. We've got some sort of reasonableness language around that, but basically they get a limited amount of time to do their trademark clearance on the the logo and the brand and come back. So you could build that into your model a little bit too if you're doing more branding.
One last point. A few of my larger agency clients will budget enough time, what I call, they do clearances for their own internal business purposes. So they don't go into pitch meeting and put something on the deck that is dead on arrival, like it's going to have a problem. So they'll hire me or another trademark lawyer to do an internal clearance. It's not something that's pushed out to the client. Representations are not made to the client, but it's to make sure that when they go in there, they're in good shape and they haven't, stepped in something inadvertently.
Simple question. Can we get it in an editable format?
Yeah.
I mean, we have to use it, but if you kind of try to grab this content and put it into something,
we can do that for sure.
Yeah, it's unformatted.
Yes, I'm fine with that too. I think we had some thoughts about it paralleling some of the other stuff that's out there, but yeah.
Yeah, awesome.
Back of the room. Oh, right here. Never mind.
So we've run into problems where, a problem, fun client, fun times. So we designed a website, and we guarantee our website is long, as we deliver it to you, it is working, it is debugged, it's completely functioning, and then we put it back in WordPress and teach them how to use it, and then they get their hands on it, and then everything goes to shit, and then they come back and they're like, "It's your fault." We're like, no. Not your fault. So is there language that we can put in a contract around that where to protect us from like once you touch it, it's on you? Or is that
Yeah. So two things there. Yes, you can have an explicit clause that says that. And you also want to be careful to generally try to limit your warranties around performance of the site to the point of delivery. So when we deliver it to you, it will conform or materially conform to the specifications that we've provided. After that, if you fuck it up, it's on you. And again, yes, you can put specific language. I don't remember whether our SOW has specific language saying, look, if you make alterations, it's going to void warranties or something like that. You don't need it. It's helpful. If you have that upon delivery, it will conform. And there would have to be something in your contract putting that obligation on your agency to deal with it in order for the clients going in there and tinkering with it, messing it up, to be your liability. But yes, it is a good idea to have that from sort of an expectation standpoint in, say, the statement of work, the document that the client might actually read.
I'll just amplify what Gabe said. So the statement of work template that we provided in the services and deliverables section actually has two subsections: included work and excluded work. So a great bullet item to put in your excluded work is fixing it after launch or after we've delivered it to you or whatever. And that it's something that you should drive home as well. But that's a good way to set expectations. And when the client asks you, say, great, we'd be happy to talk to you about that. Would you like to do an hourly SOW or a maintenance agreement for that? So your only choices are to pay me to fix what you broke. So. Yeah.
Here you go.
Long toss.
Third base to first base. The runner's coming. Oh, no.
Yeah.
Jason redeems himself from yesterday.
Yeah, yesterday was bad. So once we got, I guess, I don't know if blackmailed is the right word. We were threatened with litigation on a project just to give a failed startup some money back. So do you all have opinions about an arbitration clause or something that's...
Oh, yeah.
Okay.
You go.
You get it. So I don't need to...
All right, so arbitration. It sucks in general. And it can be used as a playful tool to not get you paid. When you are on the other end and somebody is threatening you with a lawsuit, I generally still prefer court. And the reason, I mean, if you are a giant agency and most of your clients are smaller than you, then that changes the analysis a little bit. But I gather that most of the people in this room, like most of my clients, are the smaller party, the sort of party with less leverage. And an arbitration is conducted by a retired judge looking to make a lot of money, generally speaking, in his elder or her elder years. They don't count on a lot of money from Create Legal and Groundwork Legal. They count on a lot of money from O'Melveny and Myers and Shepherd Mullen. And Shepherd Mullen doesn't represent the people in this room, but they do represent those brands and companies that you guys work for sometimes. So where do you think that that particular arbitrator's bread is buttered? You're not buttering his bread. So that's point one. Point two, they charge a shit ton. Like $1,000 an hour in some instances, $10,000 a day for some of these lovely retired judges. And the default, by the way, with AAA, the American Arbitration Association, which is really the better of the two, but the default is that for any dispute over 75 grand, it's 3 arbitrators you get to pay, unless you say 1 in your agreement. So it's really not a great tool. If you're talking about what can we do to protect ourselves from clients, messing with us like that.
Yeah, at that point, it's cheaper to give them money to go away than to lawyer up.
Oh yeah, I mean that's a difficult calculus every time, and those are very unpleasant conversations to have with clients. But there's, one thing to think about is insurance. And I've used that successfully as recently as last week to resolve something very quick and at almost zero cost to a client, because they had a good policy. If you are making an error in creating your website, or your client is alleging that, the policy should cover you there. But again, these clauses that Josh and I were talking about today, those are the things that really we're hoping in that type of negotiation and others will give you leverage.
Got it. Thanks.
So you talked about establishing this as an industry standard. But I think in the meantime, we face a lot of larger clients want us to use their nightmare contract, negotiate back and forth, get our lawyers involved. Do you have strategies for pushing as a smaller party to use a contract like this rather than that big corporate mess?
Yeah, that is a reality, and it is tough. I think the first response that you can give is that the standard agreement that the big co is putting in front of you is not customized for your specific type of work. And you'll probably be able to very easily look at a few things and identify things where it is wholly generic. And I think you can appeal and say, this is not working for either of us, right? It's generic, it hasn't been customized to it. If you are forced to deal with the big co agreement, and Gabe and I have to deal with this all the time, often our job sort of switches to, we're not going to get it, rewritten perfect like we want it to be, but we have a key list of issues of how we can get it into something that we can live with. And I bet you if we were to list our issues, they'd be pretty consistent. Pricing, one of the things I've had a few clients have success with is when they send over proposals, maybe in advance of you're just sort of pitching the work, and you've given a ballpark fee of $100,000, that you have a bullet item in there that says, this fee assumes that we'll be agreeing on terms that are substantially similar to agencies' statement of work and terms and agreement. And so if you get the pushback, if you are required to use their onerous terms, at least you've laid out a platform for you to stand on to say, okay, well, we'll work with your agreement, but as you recall, our pricing was dependent on using our agreement. Since we're taking on all this other risk, our price goes up by 25%, and make the client put their money where their mouth is. It is a tough conversation to have, to jack up the fee for the agreement, but you've set the stage for at least to have that conversation, or maybe to soften them up on negotiating their provisions.
At one point I would add is, don't you wish there was like a book or something that told you how to negotiate those? You wrote one. Recently released it, so maybe we could put it up in Slack at least or something. Yeah.
Good to see you again, Gabe. One of the things that you said early on in your talk was that you don't suggest that you kind of turn the lights off on your client if they don't pay their bill. I'm curious how, in the kind of digital environment, it's not always very easy to disentangle all of the licenses or the things that you're paying for the operation of the site. So it's kind of like there's a gray area where, if a client doesn't pay their bill with us, well, we're not going to continue to pay licenses for all the products that we use to execute on it. So if we shut those down, we're effectively shutting down their site and the operation of it. So how do you tease apart kind of those, entanglements?
I've seen clients get utterly screwed in that situation before. And it's an unfortunate reality that if you've got that sort of business arrangement and there is a dispute over that payment, you put yourself at risk by not paying that third-party service provider. So best case scenario is you don't. Your client pays that third-party service provider, and they use their credit card to pay it. I know it's not an ideal model and it doesn't work all the time, but that's the best answer to that question. The second best answer is to get very specific, and I've done this too, in your agreement, or your statement of work is probably a better place for it, where you talk about the third-party services that you're paying for on behalf of your client, and you say, look, irrespective of whether or not we are in a dispute posture, you've got to pay us for this, or this goes down. You got to acknowledge that. And I've used that, and I've put that. So you have to be really specific about it. You will get 15 days notice to pay us the 150 we need to host this platform and the 200 we need to host that platform or whatever. And if you don't, here's what's going to happen. Your whole site's going to shut down.
All right, let's go to Ron, and that'll close us out. Chris.
There you go. Oh, I'm
Nice.
a death catch.
Soccer.
It's not a legal question, but one you should have insight on. Are there insurance companies and policies that understand our business and are geared to cover the unique risks that we have to bear?
Sure. Yes, there are. If you talk to folks like, I know Gabe has a couple of good contact. The contact I had, he recently retired. So I'm using some of Gabe's contacts. But there are folks that know about this, and you have to be careful that you're not just getting off-the-shelf policies. Some of these policies go by a number of different names from the insurer, and you really need to look at what the coverages are and what the exclusions are. Often you need to get, for like the trademark protection we were talking about, often that's a separate rider under some sort of advertising insurance policy. Sometimes some of these website-related things are under like a digital asset policy, and it might also cover things like data breach, but you also need things for like when the website goes down. But it really requires a detailed review and a broker that actually knows the stuff. In video and film production, if you do any bigger video film production for brands, you'll sometimes need to talk to a proper entertainment lawyer, entertainment insurance specialist, because of all the equipment and third parties and different things that are being brought to bear in those situations.
So is that generally riders on a more general liability policy, or are these companies and policies that specialize in this area, kind of like you mentioned with the entertainment industry?
Did you do a lot of development work?
Yes.
Yeah, okay, so there is a technology errors and omissions policy is the name it usually goes by. And that, as I understand it, read an insurance policy sometime if you want your head to explode. It's true for lawyers too. There's a whole subset, there's a whole like lawyer specialty on coverage counsel. But tech E&O is something that you see a lot, and that covers, site down type errors. And if it's good, I've even seen it pick up, data breach, PCI, like credit information. And so those are the types of questions that you want to ask a broker, like, will this policy cover us if our client's site gets hacked because we failed to install an update and we were supposed to install an update, and people's personal information or credit information leaks out? HIPAA, some of them will cover HIPAA, and if you have to sign those god-awful business associate agreements, other things like that. We've put a disclaimer in our standard form about those sorts of things in the SOW, but I know a lot of my clients and a lot of people in this room are probably being asked for those types of coverages. But yeah, I think the advertising piece is on the CGL.
I think it's a rider on the CGL.
So they're two separate policies. You need the E&O and the CGL, and I think the advertising piece that gives you that trademark and other types of IP coverage is on the CGL.
But the insurance broker is probably the best source for finding the right companies?
Unquestionably.
And the insurance broker is probably the right place to find those companies?
Yes, unquestionably, yeah.